This morning we're going to talk about real estate transactions, and we'll call this the anatomy of a real estate transaction. We're going to do this in two parts, so this is really part one, and we'll follow up with part two afterwards. So usually what happens in a real estate transaction, we're going to talk about residential transactions, although commercial transactions follow very much the same pattern. Usually what happens is that you'll have a realtor involved, either whether you're buying or selling. And if that's the case, let's say if you're selling, then you're going to want to think about selecting a realtor, and how do you do that? Oftentimes what folks will do is to take a look around the neighborhood to see if there are signs from realtors in the neighborhood. You can ask neighbors or friends who may be acquainted with realtors if you're not personally acquainted with anyone. Check to see, as I said, if there are some realtors who are listing homes in your area. You're likely to find somebody who is quite familiar with your neighborhood and your area, and that is a big help in negotiating and realizing the best price for the property that you're wishing to sell. You're also going to want to interview a couple of realtors and make sure that you're comfortable with their approach and with their style of dealing with you and to dealing with your property. The next step in that process is the listing agreement, which is the contract between you and the realtor, whereby the realtor is going to list your property for sale. Be sure that you understand that listing agreement and make sure that you go over it with your realtor in detail. It will set forth who's going to pay for what kinds of services, how much you're going to pay by way of a commission, and it will also have a limit in time on how long the contract for the listing agreement will last. Oftentimes, realtors are going to want to have at least a 90-day out to maybe a 6-month exclusive opportunity to sell your property. So now we've got it listed and the realtor's out marketing it, and sure enough, now you've got an offer. This offer will come to you, or if you're buying, you will make this offer in normally what's known as a purchase and sale agreement and receipt for earnest money. That most often it will be in a form either done by the Portland Board of Realty, or sometimes there are other pre-printed forms that realtors use most frequently to put together these. The most important thing for you to understand about a purchase and sale agreement and receipt for earnest money, commonly just known as an earnest money agreement, is that it is a binding contract. Lots of people make the mistake of thinking that this is just some sort of a preliminary agreement and we'll get to the real meat of it later. It is not. It is absolutely a binding contract, fully enforceable just as any other contract. So it is not a preliminary agreement, and you need to carefully understand all of its terms and conditions. For the most part, although there are standard forms that are used, there are many parts to that form. For instance, the form itself and the contract will deal with basic terms like sale price, how much the earnest money deposit's going to be, the financing contingencies, if there are financing contingencies. There may be other contingencies in the agreement to either the sale or the purchase, depending on which side of the transaction you're on. There'll be an escrow location, for instance. There'll be inspection rights. The closing date will be set out, and conditions for closing will be there. The seller will have to prepare a disclosure statement. So if you're a seller, you're going to have a 3 or 4 page disclosure statement that sets forth all of the representations and warranties about the condition of the property, and you're going to want to be very careful how that is filled out. There'll be provisions for the title report. There'll be seller's representations in that agreement. There'll be things about environmental conditions. They'll cover prorates and when prorate dates are. There'll be dispute resolution provisions in the agreement, and there'll be attorney's fees provisions. So the point is that you need to take that earnest money agreement, the purchase and sale agreement, very seriously. And I urge you to, in fact, seek the services of an experienced real estate attorney before you sign the agreement. It's surprising how many folks I've had come to talk with me, and they've brought the agreement with them and say, and have said, here's the agreement that I've signed, so we need to do something about this. And unfortunately, by the time you signed it, it oftentimes is too late to make any changes to it. That's it for the beginning part of real estate transactions, or the anatomy of a real estate transaction. In part 2, we'll take a look at what happens when we've successfully sold the property and now we go to closing and escrow. Look forward to seeing you on that one.